Hi, I am Ruth Hay, founding attorney of Renaski Legal, and this is my short introduction to contracts. For over 15 years, I was a business and transactional corporate attorney, negotiating, interpreting, and enforcing many types of contracts. Formalities require me to mention that although I am an attorney, this presentation is only for education purposes and not to provide any legal advice. So what is a contract? First of all, let me start by addressing a commonly held misconception. Some people think a contract is a written document and an agreement is an oral arrangement. There is no difference between the use of the words agreement and contract. They mean the same thing. A contract, whether oral or written, defines a relationship. Everyone understands what they're supposed to do and what happens if they do not do what they're supposed to do. There needs to be at least two parties to a contract, but there is no limit on the number that can be involved in a transaction. The essential purpose of a contract is the exchange of promises. This means each party gives up something to get something. These somethings are as varied as one can imagine. For example, the owner of a car could sell it for cash or barter it for other goods. Or a mother may promise her daughter money if her daughter promises not to smoke, drink, or gamble. Let's say, for instance, you're shopping around for a print shop to produce brochures for your business. One printer says that he'll print 5,000 of your two-color flyers for $300. This, in legal speak, is the printer's offer. If you tell the printer to go ahead with the job, you have, in legal speak, accepted the printer's offer, and you've created a contract where you are now liable for the payment of $300. But if you tell the printer the offer sounds great, except you want the printer to use 3 colors instead of 2, no contract has been made. This is because you have not accepted all of the important terms of the transaction. However, suppose you tell the printer that you will only pay $250. If the printer then agrees to do the job for $250, a contract has been made. This is because there's been an exchange of promises. The printer has promised to print the 5,000 brochures, and you have promised to pay $250 for them. It is important to understand that the law does not require that the parties to a contract reach a perfect consensus. It is enough if the words and the conduct of one party leads the other party to reasonably understand that an agreement was reached. If, for instance, you later leave the printer a voicemail message that you will pay an extra $100 if your brochures are cut and stapled when you pick them up, the printer can create a binding contract by actually doing the cutting and stapling. And once he does so, you cannot get out of paying the extra $100. As you can see, a contract does not have to be in writing to be binding and enforceable. However, under a legal rule called the Statute of Frauds, there are some types of contract that must be in writing to be enforceable. I have provided a slide later in the presentation listing some of these. Of course, it is harder to prove an oral contract than a written one, especially as time moves on and memories fade. Also, people leave, get fired, and even die during the duration of a transaction, and the original party may not be around. A written contract will help you manage expectations with whoever inherits the project. Lastly, there are different rules between how contracts are formed and enforced depending on whether they are between individuals or business entities. But we will not be going into these differences in this presentation. Areas where contracts are needed. If possible, every business relationship should be defined by a written contract. Even relationships between family members and close friends. We all know how quickly a misunderstanding and a dispute can grow, especially when emotions and money are involved. If your business has partners, then you should have a partnership agreement, including buyout provisions or other written succession plans. By the way, if you have an LLC in Arizona, if you do not have an operating agreement, the Arizona Limited Liability Act applies, and the provisions of this act may conflict with how you wish to run your business. For example, I have a client who made a membership change but did not comply with the time constraints under the Arizona Limited Liability Act. He was not aware that under the Act, after the 30 days have passed, the corporation was actually dissolved. In light of the recent emphasis on employment classifications, I am sure you've all seen the headlines regarding whether someone is an employee or an independent contractor. You should have a written contract with all of your employees and contractors. Your clients and customers should also sign written contracts or be certain to certain terms and conditions when they purchase your products or services. If a client refuses to pay, insists that you agreed to perform more or different work, says that you agreed to charge less than your usual rate, or otherwise will not live up to his or her end of the bargain, you are in a bind. You could try to convince the court that your version of the contract is correct, but without a written contract, it will be your word against your client's, and there is no telling who a judge or a jury will believe. Lastly, if you have a website, it should have disclosures, disclaimers of privacy policy, terms of service, or terms and conditions that govern the relationship with your website visitors and customers. The contents of a written contract really depend on the circumstances of each transaction. For example, a services agreement is going to differ from a software license or a real estate lease. Some general factors that influence the contract drafting process include the relationship between the parties, each party's relative negotiating leverage, the size and scope of the transaction, the creditworthiness of the buyer, the reputation of the seller, and each party's risk tolerance. Most written contracts should at a minimum include the following: the full legal name of each party, the contract effective date, descriptions of who is doing what, by when, and for how much money, payment terms and timeframes. Don't forget to mention any additional expenses. A suitable termination provision. Everyone behaves better when they know the other party can easily get out of a transaction. A limited warranty. If you do not limit your warranties, contract laws allow for very broad warranties. A cap on liability that is appropriate to the size and scope of the contract. You don't want to risk your assets or your home for a small contract. And lastly, how long the contract will last. Obviously, there's a lot more that goes into a contract, such as what happens in a dispute, but the items previously discussed are the starting items. Do not forget to check any financing agreements you have. They may limit what you can promise your customers or limit what you can do in the event of a dispute. Lastly, try to avoid agreeing to personal guarantees which make you personally liable instead of your company. Most contract breach complaints concern one or more of three areas: a financial breach, you didn't pay me; an operational breach, you or your product didn't perform as promised; or an impact to one's reputation. Your breach affected my business or customers. There are different approaches and remedies for each breach scenario, which we do not have time to go into in this presentation. However, the most common form of legal remedy for a breach is the award of money damages. There are two general categories of damages: compensatory damage, also called actual damages, which cover the loss the non-breaching party incurred as a result of the breach of contract, and special damages. These are called consequential damages, which are damages because of a special circumstances that were not predictable. To give an example of how the concept of damages works, consider the following scenario. Company A delivered the wrong kind of furniture to Company B. After discovering the mistake later in the day, Company B insisted that Company A pick up the wrong furniture and deliver the right furniture. Company A refused to pick up the furniture and said it could not supply the right furniture because it was not in stock. Company B successfully sued for breach of contract. The compensatory damages for this breach could include a refund of any amount Company B had prepaid for the furniture, plus reimbursement of any expense Company B incurred in sending the furniture back to Company A, plus payment for any increase in cost Company B incurred in buying the right furniture or its nearest equivalent from another seller. To take this example a step further, if Company A knew that Company B needed the furniture on a particular day because its old furniture was going to be taken away the night before, the damages for the breach of contract could include all the damages previously discussed, plus payment for Company B's expenses in renting furniture until the right furniture arrived. This is an example of consequential damages. If there is a breach of contract, a party may, in rare circumstances, sue for specific performance. The most common reason courts grant specific performance is that the subject matter of the contract is unique. Real estate is considered to be unique, and if the seller of a house decides to keep a property after previously promising to sell it, the buyer may be entitled to specific performance, and the seller will be compelled to go through with the sale. The amount of damages depends on the type of contract that was breached and the type of loss incurred. A general guideline is the amount that would have put the non-breaching party in the position he or she would have enjoyed had the contract been fully performed. It is important to understand that generally damages are not used to punish or to create a windfall for the non-breaching party. The damages calculations for contracts for the sale of goods is the difference between the contract price and the market price when the seller provides the goods or when the buyer learns of the breach. An important limitation on the award of damages is the duty to mitigate. The non-breaching party is required to mitigate or minimize the amount of damages to the extent reasonable. Damages cannot be recovered for losses that could have been reasonably avoided or reduced after the breach. The non-breaching party's failure to use reasonable diligence in mitigating the damages means that any award of damages will be reduced by the amount that could have been reasonably avoided. On this slide, you can see some of the typical problems that occur when a written contract is used. It is important to understand that a contract written for one transaction often is not a good fit for another. I see this a lot with my small business clients. Also, some contracts pulled from the internet do not accurately reflect state and federal laws. You will be surprised how many times I've received contracts that do not have the correct legal name of the parties or are unsigned. Also, I frequently see contracts that literally have blanks or do not address key items, such as the amount and type of product to be delivered, when services are to be performed, and even how much should be paid and when. This is especially the case in relationships between friends and family members. If there is something that a party has been promised, but it is not written in the contract should not be signed. Once a contract is signed, it is enforceable as it is written. A good contract is easily understood by anyone that reads it, and not just by the parties to the contract. Try to avoid using terminology and acronyms that are not commonly understood or not used outside of your business industry. It is important to understand that, except in the case of fraud, none of the parties' negotiations, intentions, promises, or statements that are not actually included in the written agreement will be considered by a court in the case of a dispute. A written contract can only be changed by a later written and signed amendment or a new contract. Written contracts cannot be modified orally. This is important to remember if an estimate is incorrect or the scope of work changes. In Arizona, there is no stupid contract law. This means anyone can make a contract that is not smart or fair. It may be possible to argue some exceptional defenses to try to invalidate a contract, but a court will not invalidate a contract just because it does not make business sense or was not financially wise. Please take a moment to look at this slide listing some of the contracts that must be in writing to be enforceable, especially if you sell goods that total $500 or more, or provide services that cannot be performed in a year. Providing a contract makes you look professional. It shows that you know what you're doing, that you are proud of it, and that you stand by your word. You can even use a little reverse psychology and tell your client that you use legal documents so that they have confidence that the job will be done on time and in a professional manner with care and skill. Use a legal agreement simply because it will protect your business. It is highly likely that it took you a long time to get to where you are today. Don't risk falling behind and having a claim made against you or your assets by neglecting the basics. I hope this presentation has been helpful to you, and please feel free to reach out with any questions you may have regarding it.